What's the name of this? Do you guys want?
To start. Welcome, everyone. My name is Teresa Hall. This is Patty Fox. We did this program several years ago, and were any of you here at that point in time? Several. Okay, you might hear the same stories, but we were asked to come back. And the reason that we did it several years ago was because we had a conversation, and the conversation was on a long drive back home from Telluride, but we both started telling end of life stories that had impacted us related to our own family members and what had gone well with that and what hadn't gone well with that. And it sparked both of our interests to maybe look into what can make that experience better, because we had both had some things that happened that maybe didn't have to happen, or that we could change in our world. In one of my recent experiences, about 10 years ago, my stepfather developed stage 4 lung cancer, and he was terminal and in the hospital. And he was there with all of my siblings, my step siblings, and I, and my mother, who had early dementia. And he turned to me and he said, "Be sure and take care of Shirley," who was my mother. And I said, "Okay, I'll do my best. You tell me, where's your will?" And he looked and he said, "We don't have one." And I thought, okay. So I was able to contact an attorney in my family's hometown who came to the hospital and met with my mother and my stepfather, and they got a will. And about 10 days later, he passed. My mother developed dementia, and dealing with a blended family, I was really happy that we had that will as a document to work from. Thinking back, I wonder, why didn't they have a will? Did they not know they needed one? Or they didn't have the money? Or they just thought they were going to live forever? I'm not really sure. They had a cemetery plot, so they were thinking some things. But it was those kinds of questions that made me realize I did not want to put my own child in that sort of a position, especially a child who lives out of state when we live here. How could we get our lives in order? So after Patty and I had a discussion, we started working on, we spent about a year doing research on what really do you need to have, or what's helpful to have at the end of life. None of us know when we're going to go. We don't know how we're going to go, but we do know that it's likely that at some point we all will. And as a gift to those who are left behind, and just to give our own selves peace of mind, I think it's helpful to know some of these things. Obviously, Patty and I do not profess to be professionals in this area at all, but we've developed this interest. And so hopefully over the next several nights, we can share some of that with you. Tonight, we are going to look at some legal issues.
Looks on the video.
And next week, we'll be looking at some medical issues as well. After the workshop several years ago, my husband and I did meet with our attorney. We did get our papers in order. We have a will, we have our power of attorney, we've got all that estate planning done, but we didn't delve deeper.
¿Verdad? Ya lo de los pecados no creo, ¿no?
And you have really impressed me. We say the most important thing that you can do to all that is share that information with your family. If you have a will and he knows where it is, it's worthless. So I'm gonna let Patty tell you what she has done, because I'm pretty impressed.
So Teresa and I started at the same place more or less, except that I had lost my husband 10 years earlier. And he died of cancer in our home with the help of hospice and my daughter and his brother. So it was a very close-in situation, and for which I'm eternally grateful. And, he had had cancer for 25 years. So we knew that someplace along the line, we were gonna need this paperwork done. And we had a will and we had, an estate plan. But we hadn't actually talked about what he wanted for his end of life. And so as the end came and he became less communicative, I was left with making decisions that I really wish he had made and had shared with me. And so when Teresa and I started talking about this, the first thing that I started thinking about is, what are the hard questions that I wish we had talked about, that I wish he had shared with me? And so the first paper that you will have in your red folder when you leave today,
It's all about the red folder.
it's all about the red folder, is a paper that says some hard questions. And what I found after I filled out that paper was that the rest of the questions that I needed to answer came much more easily, because I had said, this is what I want when I am dying. These are the things that would bring me comfort. This is how I want my body handled. This is how I want to be buried or cremated. So those were pretty hard questions to address. And I felt really good after I addressed them. So that's the first paper in your folder. Yikes. The next paper in your folder will be a paper that's called a personal information. And it has two sides and it has so many questions on it, because the personal information you need to share with the people who are going to handle your estate after you pass includes your legal name and all of the passwords for your computer and your phones, and all of your employment information, your residence, where your titles are, your mortgage, if you have a mortgage, your landlord, if you're a rental, all of this information. When I made this long list up, I thought, oh gosh, what an awful lot of things to do. But I took one section a day. I just set myself a week and said, this is what I'm gonna do. And I filled it out, and this is what I have. Less than a full page. Because it really isn't as hard as you think it's gonna be. Your insurance is probably all with one person. Your titles, you know where they are, they're in a state deposit box. So it wasn't as anywhere near as daunting as I thought it would be. Also in your folder, you'll have a declaration of disposition of last remains, and you'll have a state of California, state of Colorado transfer of title, so you can transfer the title upon death of any of your vehicles, so that somebody doesn't have to dance through a lot of hoops.
Talk about that, the last remains, what is that for?
That's unfortunately, you have to have a declaration of last remains in order to be cremated in the state of Colorado. And if you don't have that written up, somebody, whoever is handling your estate, has to jump through a bunch of hoops. So this is just to make it easier for whoever is going to do that.
So you put all this in a file, and then on your 80th birthday.
So then on my 80th birthday, which was this year,
Yeah.
80, good grief. All of my son and his wife and my daughter were all with me for breakfast. We didn't do a big party, but we had breakfast together. And I had written out a letter that stated what I had done. And I addressed it to each one of them and handed it to them at the breakfast table. They opened the envelope. My daughter burst into tears. My son sort of got choked up. And my daughter-in-law said, "Do you want me to read this out loud?" And so she did. And here's an abbreviated version. Because as it says over here, the most important thing that you have to do after putting the paperwork together is to share it. Dear family, I've compiled all of the important documents you'll need when I die in the red folder in the file next to my desk. The legal ones are in the safe deposit box, and you are both signers. Although I've talked about the long-term plan for my health, wealth, and inheritance, when the time actually comes that you have to make hard decisions, one forgets or feels guilty or can't agree. So I'm giving you this letter on my 80th birthday when I'm in good physical and mental health. And I hope this will help make my wishes clear when or if I can no longer communicate them. If my physical and mental health are good enough, let me make my own decisions and live as independently as possible, as long as possible. If I fall and break myself and no one is there, well, so be it. Don't protect me from myself, and don't feel you should have if something happens. If I can no longer care for myself physically or mentally, make the best decisions you can for my care, but do not sacrifice for me. Care is very expensive in our valley, and you may find a care facility at a distance. And that's okay. And this is a question actually we will discuss next week. If I just grow old and you wish to care for me in my house or yours as my death approaches, that would be my preference. I have notes in my red folder that you'll want to review when that time comes. I hope and believe that will help you find peace in my passing. I hope I don't try to hold on to a failing body, but if it looks like I'm trying to do that, please remind me that it's time to cross back across the rainbow bridge into the light where my guardian angel will greet me with the wings I left with him at my birth.
Beautiful. Hard to write.
Hard to write, hard to read, but clear, and it really, after we came to the end, everybody cried and laughed. And it was the way it is.
How
So-
did you feel elevated after you?
I felt fantastic. I felt fantastically relieved, and I think they did too. They felt like, Mom, you know, we talk to our friends who do not have a mother that's done this, and they are so distressed about it. And my kids say, we got it all, we've got it done. And but that's only the beginning, because of course, filling out the paperwork was what I could do. But then I had the legal and financial part of it to take care of. So shall we invite our speaker?
Yes.
Ken Ransford was wonderful. He spoke last 2 years ago when we had this workshop. And after he spoke, I went to him with all of my paperwork, and he helped me really redesign some things because my life had changed. And that's one of the questions that we'll be talking to him about. How often do we have to ask these questions? So, welcome. Ken is an estate planner and an accountant here in Basalt. And I've got a bunch of you already know him. So, welcome, Ken. I'm going to let you hold the mic, and I'm going to just ask some questions so we don't have to go back and forth with it. So the first question I'm going to ask you is that, most of us know that we ought to have some paperwork. But what about the young people? What should everybody have in their files someplace, no matter what their age? Because I'm sure many of you have children or grandchildren and you're wondering, what should they have in paperwork? So let's start with that question.
Okay, well, first let me introduce myself. It's nice to see some familiar faces, a lot I don't recognize, so that's good too. I am a attorney and a CPA. My office is up the street here at the Midland Avenue Mall, right across the street from the Alpine Bank. The Mountain Heart Brewery is downstairs, right below my office, and it keeps reminding me how boring I am compared to everyone downstairs. But I've been practicing since 1984. I went to the University of Colorado Law School. I moved here in 1978, just after college, and lived here for 3 years, and then went down to Boulder and went to law school there. I worked in a CPA firm for 6 years, and then I took 2 years off with my wife, and we lived out of backpacks, and we traveled through Asia. And I came back and started my own practice in 1993. So I've been doing this for a while. And I'm a solo practitioner. I have several people who work with me, but I need to find a legal assistant to take over my practice, but I don't have any immediate plans to retire. And so I bring both a accountant and an attorney's perspective to my work. And I usually take on work that has a tax angle to it. You know, estate planning usually does have a tax angle to it, so that fits. But I don't practice. I once was at a bar meeting and I asked a lawyer what he did here in this valley, and he said, "Oh, I do what everybody does." And I said, "Oh yeah, what's that?" He says, "Well, I do personal injury, real estate, and divorce. But those are 3 things I basically don't do." So let's get to your question. So that is, what are the essential documents that somebody should have? I personally think that having powers of attorney is really important. And so those operate during your life. Upon your death, the power of attorney expires. The agent loses authority because you're now deceased. But I prepare 2 in my office, a financial power of attorney and a medical power of attorney. And I combine the medical power of attorney with the living will. And that's the document that says that you empower your agent to discontinue life support in case you're in a comatose situation or you have a terminal illness from which you're not expected to survive more than 6 months.
And I'm going to interrupt just for a moment to say that next week you will have a booklet that will have several of the medical legal papers in it.
Right.
So you'll be covered.
But people who like to sell insurance promote disability insurance. I'm not a big fan of insurance, and I don't encourage my clients to go overboard purchasing insurance. But the people who try to sell disability insurance say correctly that you're much more likely to be incapacitated but not die than you are to pass away. And that's what a power of attorney is for. And imagine if you have a stroke and you don't have the ability to communicate. That's what your power of attorney is for. So even young people could need that. And so I actually think that's often a more important document than your will, at least as you're younger. As you get older, your will is obviously very important. What I spend a lot of time in my office dealing with is who should your agents be? And that's a really big and important decision. And I know I often see couples want to name all 3 of their children or both of their children to serve as co-agents. And I'm not a big fan of that. Personally, for me, it's a lot easier to deal with a single person than to deal with co-agents, because then you have to get both to agree on everything. And that's not always that easy, and it adds a lot of time in my office to have to get 2 people to sign something or 2 people to agree to something. So I actually favor a series of agents put in order. Now, if you have one that's local and one that's far away, and you still want to name both, I think that's fine. But then I also recommend that you say that either agent has the ability to act on their own. And you encourage your agents to communicate with each other, but either one of them has authority to act alone. That makes it easy for the bank officer across the street. If you go in, if an agent goes in, hey, I see there's two agents here, but one of them, only one of them has to sign documents. So that's another thing I'll put in that agreement. But I spend a lot of time on who your agent should be. But that document is, that rises to the top. The document you ought to have right now, that's just a power of attorney that acts while you're living as, but you don't have capacity to make a decision. Now, one last thing I'll say about this before giving you back the mic is, especially with the medical power of attorney, the document does not require your agent to do anything. It empowers your agent. So if your agent's at the hospital and disagrees with a doctor's recommendation because the agent has spoken with you and you've communicated with them what you want to have done, that document, the medical power of attorney, allows your agent to, in a sense, guide the doctor. Overrule the doctor is pretty strong language, but at least to communicate with the doctor, say, no, I've discussed this with my mom and this is what we talked about, and I don't think she would like this. But the point I'm making right now is the document empowers your agent to do things. It doesn't force your agent to do anything. So let me turn it back to you.
Thank you. So that's one important document to have a power of attorney. How many of you have a power of attorney? Well done, well done. And we will discuss that further also. So everybody should have a power of attorney, but how does your plan change as you age? Let's say that you're now 40 and you have young children. What new considerations do you really need to take in?
So we talked about this too. What you want to do is make it easy on your children and not make your lifetime a burden for them. I spent a lot of time thinking about that as well. We've already talked about that. That's why I like one agent instead of two co-agents. That's simpler for your kids to manage things. As you get older, I recommend that my clients see me every 5 years or so, or after a major life event, like the birth of a child or the death of a spouse or the death of a child. Those are times when I recommend you come see me. But so you're in your 40s, and what would I recommend then? I would say you definitely want to have a will or a trust put in place. And let me talk a little bit about the difference between these. Your will, we all know about. This is my last will and testament. And you designate who receives your assets. You really have to know two things in your will. First, what are your assets? And two, who are your beneficiaries? And if you state those two things in the document, that's really what's important. But that's just really the first basic step. When I've been doing this work since the early 90s, so for over 30 years now. And for a long time, I said, probate is not a big deal in Colorado. It's a lot simpler than it is in other states. But as I've gotten older and as my client base has gotten older, I'm finding that probating estates is actually a fair amount of work. And you can avoid a lot of that if you set up a trust now. And that's what I prefer. And the reason is this. I define probate as changing title to your assets. You have a bank account in your own name and you pass away. How do we get that bank account out of your estate? Well, if you have more than $90,000 of assets in your own name, we have to open up a probate estate in the county where you live. And that involves filing a half a dozen pieces of paper, and it has to stay open for 6 months, and you have court filings and you have deadlines, and that's a fair amount of work. And here in Colorado, we have 65 counties and we have 65 different ways of doing probate. And in this county alone, we have Pitkin, Eagle, and Garfield County. In Garfield County, you can't open a probate estate unless you send them the originally signed will. So if you don't have the original will, now what do we do? I haven't had that problem yet, but I'm not sure what the answer to that is. In Eagle County, they'll open the probate estate with a copy of your will, but they want you to send it to them. And in Pitkin County, they don't want to see your original will. They want you to say you have it. But so here are 3 counties in this valley, and they all handle probate differently. So that's what that's aggravating for me to have to learn all these different ways to do the same thing. And so a trust avoids this. And the reason is when you pass away, your assets are titled in a trust already. And you don't have to change title to them. Your trust has already done that. And before, I would tell my clients, if you set up a trust, you're going to have to retitle your assets now into the name of a trust. And you're also going to have to go through probate when you pass away. So you might as well just wait until you're deceased before you do this asset title changing. But I've changed my opinion significantly, really, since about the time of COVID. And I'm finding that if you retitle your assets in the name of your trust right now, then that really simplifies things for your children because they don't have to go through that. So one of the most aggravating things I deal with is trying to communicate with Charles Schwab or Fidelity or Morgan Stanley on the phone because they don't know me from Adam. And they don't trust me, and it's hard to get them to do things that I want them to do, but not if the client's right there, not if the client has capacity. So they talk to them and they've got voice recognition, they recognize them. That goes pretty smoothly. The point I'm making right now is while you're alive and you have capacity, it's easy to change title to your assets. If you have a stroke or if you lose capacity, that gets much harder. And much harder means it takes me a lot more time. And that means my fee goes up because it takes me more time. So I like trust because you change title now while you're living. And it makes probate much simpler for your children. Probate, again, changing title to assets, but it simplifies that process. And that means a lot. So I'm going to turn it back.
That was very informative, and I actually went through all of this with Ken, and it was a couple of sessions, but it wasn't arduous. And I really was very grateful, and it has relieved me of a tremendous burden. Luckily, my son was able to go through it with me, so he's very clear on it also. And one of the things that we also talked about, Ken, was generation skipping. And if you will hold your questions, maybe jot them down. We're going to have some question and answer at the end also. But this is a question that we talked about. What is generation skipping?
So this is the part of my practice that I dread discussing with my clients because generation skipping tax planning is complicated. And I was at CU Law School from 1981 to 84. And in 1976, Congress passed the generation skipping tax. And I remember on the bulletin board for the law students, some teacher had thumbtacked up this piece of paper. It was half of an 8.5 by 11 sheet, and it quoted a statute from the generation skipping tax. And at the bottom of it, she had typed in, "If you don't understand this, you better take my class on estate planning." And it's gotten no better. And most attorneys, roll their eyes when they hear it. What it is, here's why I like it. Let me cut to the chase. Colorado has a case that says that if you inherit your inheritance in a trust that your parents allocated their generation skipping tax exemption to, and if you go through a divorce, your divorcing spouse can't access this trust. It's hands off. And I've been through that now several times with my clients, and it's really been a lifesave because my clients have left, a significant inheritance to their children. They pass away, their child inherits their estate in this generation skipping trust. They go through a divorce, and their spouse says, "I'm going to make a run at that trust." And I get a call from the spouse's attorney, and I say, "Well, you probably can't. This is a generation skipping trust. Look at this case, Henry Gwynn." And I never hear from the attorney again, and it's really bomb-proof. It's worked every time so far. And the upside is you're protecting your inheritance to your children so that if they do go through a divorce or they have some other creditor coming after them, it's probably going to be beyond the reach of that creditor. The other likely creditor these days, besides a divorcing spouse, is frankly Medicaid, in case you go into a nursing home. And if you go into a nursing home, you have to spend all of your own assets down to pay for that nursing home coverage. But if you have inherited a trust, then that's what we call a third party settled trust. Some other party created that trust and gave it to you. That's why it's a third party trust. Then that's beyond the reach of Medicaid. And so you can protect your inheritance for somebody who has that situation. They go into a nursing home. So I end up using the generation skipping tax trust planning a lot in my practice because it really is bomb-proof creditor protection for the kids. It also means that if they were to have a taxable estate, the generation skipping trust doesn't get included in that. So if you have a child who happens to work for one of the 5 companies that's causing half of the growth in the S&P 500 every day, and he's done very well or she's done very well, then if you leave your assets to them in a generation skipping trust, it doesn't get included in their estate. So they don't have to pay estate tax on it. But the real reason I like it is because of this case, in remarriage of Gwynn, that really provides really strong creditor protection for your kids. They inherit from you in a trust, and they don't have to worry about that being an asset of contention in a divorce. And as I explain to my clients, you haven't made your inheritance to your kids the main thing your child is fighting over in the divorce. You basically can take your inheritance and just put it to the side. We're not going to talk about this in this divorce. That's why I like that plan.
And that does apply more often than we like to think, especially for our kids. Should you have additional signers on your bank account?
Yes, this is a good idea, but it's also one that I'm always, I always have to stop and think ahead of time if my client asks me that. And here's why. If you put your child on your bank account as a joint signer, that kind of gives that child this carte blanche authority to go act as though that's their own account. And if you fall into dementia, and we know dementia isn't a all or nothing thing, it's something that happens over a long period of time. If you put your child on your account as a signer, they can then go and transfer that account into their own name. And if you've lost capacity to really know what's going on, then that can be an outcome of that. So an alternative would be to make this account payable on death to that child. So that doesn't give them current signing authority, but it makes it an account that's payable on death to them upon your death. And so I also have to stop and think before I say that's a good idea with my clients, because the way a payable on death account works is I've got a bank account at Alpine Bank. Upon my death, I want it payable to my son, John. And then they also have another bank account, community banks, and then they say, and upon my death, I want this bank, community banks, payable to my daughter, Susan. And so I'm nervous about you ending up with different payable on death designations for different accounts, and that we forget what we did, and years go by, we can't remember what we did, and now you've kind of got several wills going on here. You've got a will that says you want to leave everything equal to John and Susan, but now you've got these different payable on death accounts that are leaving money to different people in different amounts, and so we tend to start losing track of that. So, and before I hand it back, let me just say one more thing about IRAs. You also want to have your beneficiary designations current on your individual retirement accounts. This is something that a 40-year-old family, or 40-year-old couple, I would talk about with them. They have one child, and they may have another, and their beneficiary designation for their IRA says they leave it to that one child. in case both of them are deceased. And then they have another child and they do not update their beneficiary designation. And so now you've got that same mismatch that I just talked about. So that's another thing I go over when you come in is what are your IRA beneficiary designations and are they current? So yes, these things have a place, payable on death designations and of course IRA designations, but we have to be careful that they stay coordinated with your estate plan.
And what if you have property in another state? That creates some problems also, doesn't it?
Yes. Yes, it does. Usually good problems, but not always. This comes up a lot in this valley. I have clients who, I've had to learn a lot of state laws because clients have vacation homes in different states. And almost everyone here has moved here from somebody else and they've got ties to other places. So if you own real estate in another state, you're gonna have to open up a probate estate in that state upon your death, unless you've taken steps ahead of time to put that property in trust or in an LLC. And those are the two common forms of ownership for real estate out of state. I personally like a trust more than I like LLCs. And the reason for that is if you have an LLC that has multiple owners, like several people own this vacation house in Maine, technically you have to file a partnership income tax return. And that's work and expensive. And if you don't have to do it, let's not do it. Or or you have an annual filing requirement with the Secretary of State, and you've got to keep that LLC current. And if you miss that, then it goes it basically gets dissolved by the Secretary of State because you haven't renewed it. So those are two problems with LLCs: the potential tax filing requirement. I'm the CPA you want to have because I hate filing tax returns. And if I can avoid them for you, I will. I spent a fair amount of time figuring out how not to file income tax returns if we can avoid it. Well, that's one I try to avoid. And a tax return for a vacation home in Maine, that's an unnecessary filing. But a trust avoids that. So you don't have to renew a trust, but what you've done by putting your property into a trust is that it's now owned by another vehicle, a trust. So that if you passed away, that trust lives on and continues to own that real estate in that other state. And you don't have to open up a probate estate in that state. But if you own a property, or if you're a tenant in common together with siblings on a property in another state, now you're gonna have to open up a probate estate or hire an attorney in that state to administer that property. And then the last thing I'll say is, I started out saying this, but I roll my eyes when I have clients talk about vacation homes that they own jointly with other siblings. I find joint ownership of property takes up an inordinate amount of time in my office that, it's a fairly rare family that has a vacation home that they own jointly that doesn't cause discord. And, they fight over who gets to use it. They fight over who has to take care of it. It's human nature. We had a property in my family. I'm from California, but I'd be fifth generation if I were born here. And we had a house at Grand Lake, my family, and it was sold in 1964 when I was 8. And looking back, I thought that was a great move. Otherwise, I'd be having to take care of that property. And instead, I got to go kayaking every weekend instead of having to go up to Grand Lake to care for this property. But I'm being a little bit facetious, but I encourage my clients to think long and hard about whether or not they want to hold on to a property or leave it to kids jointly, because I've seen that really cause, more trouble than it's worth often.
Do you have some questions, Teresa? I have a couple more and then we're going to turn it over to.
Okay. No, go ahead.
So what happens when a person has some assets, passes away with no power of attorney and no will? What happens to the assets?
So this is called dying intestate without a will. So the person who signs the will is the testator, and that word, the root is testament, last will, and testament. And so if you hear the term testamentary trust, it shouldn't scare you that much. All it means is it got created by the will. And so the testator is the person who creates the will. You've heard of the word last will and testament. But if you die without a will, then you're set to die intestate. And so you've now passed away without a will. So we have a fairly elaborate statute that says what happens if you die without a will, who inherits your estate. And it's really complicated. It gets amended often by the Colorado legislature, and I have to read it every time to see how it applies with my clients. And the reason is for the following. What if you have a spouse or you don't have a spouse? What if you have a spouse who is the parent of your children? Or what if your spouse is not the parent of your children? And so you start to go through all these permutations, and it ends up being a very complicated statute. And it's probably not going to do what you want to have happen. And so dying without a will, if your situation is very simple and you have a spouse who's the mother of your two children and you die without a will, that's a fairly simple situation. But if it's not that simple, then it's probably going to be a problem. And so you'll have to open up a probate estate. There's a line of succession of who would serve as personal representative. But it takes a lot more handholding. All of this is easier if you do this while you're living and when you have full capacity. As you get older and you lose capacity, all these steps are harder to do.
So what is the one mistake that you see that people make most commonly in planning their estates?
So that's really what I just finished off with, and really that's waiting too long to create documents. I had a client who was referred to me, and she was born in Switzerland and lived here for most of her life. But by the time I was introduced to her, she was in heritage, and I prepared a will for her, but she had gotten to the point where she couldn't really remember who her heirs were, what her assets were. She had a CPA who was caring for her and handling her finances, and she was doing a great job, the CPA. But I prepared these documents for her, and I couldn't get her to make an agreement, and they've never been signed. So that the illustration is, if you wait too long, that's a mistake. And so that's the first on my list. A second one is not telling me that your children don't get along. So trust me, I'm gonna find that out. But if you tell me ahead of time, we're gonna discuss it and we're gonna come up with a plan for that. If you don't tell me that ahead of time, and I have both of them having to agree on every decision, for example, or other things like that, then that's a big mistake. I'm just gonna say this outright. There's not a single family out there that doesn't have problems, and I'm gonna start with my own. But it's just every single family I've ever seen has issues. It's just part of our nature. That's who we are. And I'm not being critical, I'm saying it's human nature. And so hiding that is not a good idea. So that's number 2 on my list. Number 3 is choosing the wrong agents to administer your estate. So I had this case where this woman lived in Aspen. She probably would have been a friend of mine and a ski buddy. She was single her whole life, and she left her estate to like 10 of her best friends in small amounts, like $5,000 each. And the person to administer her estate was living out of a van. And one of the persons had moved to Mexico and then become infirm and gone into a Mexican nursing home and then died there. And so I had to get a death certificate for that person. And this fairly small estate took as much time as any estate I've ever administered. And I was sending FedEx packages out to Palm Springs, so the person would show up there in her van and get them, and it was just a nightmare. So choosing the wrong agents, I'm going to say that. We've talked about this a couple times. I spent a lot of time on it, but who is a good agent? A good agent is somebody who you can trust. They can be your age. I know you like to say, oh my gosh, I better have someone younger than me, but they can be your age. And then I'd recommend naming a couple, but it has to be someone that you trust, and it has to be someone that's easy to work with. For me, an agent who lives in this valley is a lot easier than someone who lives far away. It's really nice for me to have them come in and I prepare a document for them to sign. Oh, this is wrong, and I change it on my computer and print it out, we sign it right there. Whereas if they're an agent in New York, then I've got to either send a PDF to them or send a FedEx to them. And all this takes 2 or 4 times as long. So I like an agent who's here and someone who's competent and someone that you trust. So next, picking too many beneficiaries for charities. It's expensive to make a lot of estate distributions, and there's no way you can scale this thing. So if you have, if you leave your estate to 4 beneficiaries, or you leave it to 12 beneficiaries, it takes 3 times as long at least to deal with 12 beneficiaries, more, because that's just so complicated. So beware of, if you're single out there and your friends are the people that you met the first week you moved to Aspen and it's still that way, do yourself a favor, don't name all of them as the beneficiaries in your will. So naming too many beneficiaries can be a problem. Waiting too long to make end-of-life decisions. Colorado has an end-of-life options act. Let me talk a little bit about this right now. And we were one of the first states to pass it, probably about 12 years ago. And what it says is that you can drink a cocktail that will cause you to die. And the requirements are such that I think it basically works if you have cancer. If you have cancer, this is a legitimate option for you, but most other diseases don't fit it. It doesn't really work for it. Here's what is required. You have to discuss it with your physician. Yes, you have to first have a terminal condition when you're not expected to live for more than 6 months. So you have to have a terminal condition. Then you have to discuss this with your physician. Then you have to wait 15 days and come back and have a second discussion with the physician and say, you still want to do this. You also have to get a second opinion from another physician who says you're cognitively capable of making this decision. And so, and then they'll give you this cocktail, and then you have to be able to drink it. You can't take it intravenously. So you can't take it as a shot in your arm. You have to be able to drink it. And I just went through this process for me the first time with a client recently, and I found that it was, how do I say this, really amazing experience. And what I left with was how courageous this woman was to drink this cocktail, because at the time, it was a beautiful day. It was a bluebird day here, and that was the best day she'd had that week. But when I came in and saw her at 10:30 in the morning, I wasn't sure if she was going to go through with this decision or not. And she ended up going through it. And it was a really good decision because she had terminal cancer and she had really been declining. And that last week was a really bad week for her. And the nurse, the hospice nurse who was there while she drank this cocktail, said if she hadn't done this, she would have spent the next 2 to 4 weeks lingering, and they would have been the worst 2 to 4 weeks of her life. And that's why I say that I thought it was such a courageous decision to make. I think it took a lot of courage to do that. I think it was the right decision. Her other close friends were there with her. There were about 4 of us. And sitting outside in the backyard, beautiful bluebird day, dandelions on the lawn. She drank the cocktail and she followed up with a glass of wine. And less than a half an hour later, she basically did that, tilted her head back. And they're not always that simple, but it was a really painless way for her to go. And right at that moment, she's sitting in the chair. The nurse came and tipped her head back, but she's now passed on. And someone said, "Oh, gosh, what's her phone password?" And I felt like, oh, she's sitting right here. Well, let's just ask her. And obviously we couldn't do that, but we did have the phone password. Make sure you write down your password. That's a good idea. And also let us know if there's someone that, if you have stuff on Facebook accounts or other accounts that you don't want people to see, let us know that also. That's also really important. Communicate that. But I I thought it was really a good decision that this person had made. And but again, it's not going to be available if you have dementia because you don't have capacity anymore. It's not going to be available if you've got a stroke and you can't swallow, because you have to be able to swallow this. So it's not for everybody. I think it's primarily available for people who have cancer. So
Parkinson's, ALS.
pardon me?
Parkinson's or ALS.
Parkinson's or ALS as well. So a nurse would be better discussing this with than me. But I did want to talk about that experience.
This is a lot to take in. And, Teresa and I have been talking death for several years now. And so for us, it's a little bit easier, but for most people, it isn't so easy. And we wanted to sort of acknowledge that and encourage you not only to find the legal financial help you might need, but also counseling. There's some wonderful counseling available in our valley. And if it's a little difficult for you, we understand. It's difficult for all of us. Questions?
I have a question.
Yes. I'll point to you as best I can. Yes, that's great. Yeah.
I just had a quick question because I may have misunderstood earlier. You were saying at the end of life that the Parkinson's and Alzheimer's is, no, it is not allowed.
Parkinson's, yes. Alzheimer's, no.
ALS.
ALS.
Can you repeat the question because I'm hard of hearing and
Yes,
Can you
she asked for whom is medical aid in dying available?
okay. Thank you.
Mhm. In the back there on the right?
Can you explain the difference between a revocable and an irrevocable trust, and what would be recommended when you're talking trust?
Well, yeah.
Which
Well, the question is, what's the difference between revocable trusts and irrevocable trusts? So in my office, I like to use the Good Witch of the East in the Wizard of Oz to describe trusts. And a client recently pointed out to me that her name was Glenda. And I use that because I say Glenda comes floating down to Oz and steps out of the bubble. And the bubble is the trust. And what it is a whole bunch of legal attributes to this document. So you just asked about one attribute of this trust. Is it revocable? Can you change it? Or is it irrevocable? You cannot change it. And so I use both all the time in my practice. So if you come into me and you say, you know, I want to create a trust so I can avoid probate, I'll create what's called a living trust for you. And it's called a living trust because it's set up while you're living and it's funded while you're living and it's operating while you're living, as opposed to a testamentary trust, which springs into existence from your will upon your death. That's not funded while you're living. That's a trust that hasn't yet been funded. But so if I create a living trust for you, one that you change title to your assets to today and retitle them in the name of this trust, and you serve as the trustee of the trust, so you make all the decisions for it, then that's going to be a revocable trust, and you can change that at any time until you either become incapacitated or you pass away. At that point, it becomes an irrevocable trust. But that begs a question in my office. At that point, do you want someone to have the ability to change your trust or not? And if you're a married couple that you've been together for 40 years, I'm going to suggest you do make it revocable still by the surviving spouse. On the other hand, if you came into the marriage and you have children from a prior marriage, each of you, then I'm gonna probably say that trust ought to be irrevocable when one of you becomes incapacitated, because, you know, we've got two sets of children that we're potentially benefiting. So, and then there are other kinds of trusts that I create, where I'll create trust for children, for example. The parents, I favor my parents giving what my clients, giving assets to their children sooner than later. They can afford to do that because we're living, you know, our our parents are dying when we're in our 60s and 70s. And so when we inherit money at that stage of our life, we often don't need it. While our children, one generation down, can really use it in their 30s and 40s. So I encourage my clients to give away assets later often. But in that case, that trust will be irrevocable, most likely. That's the trust that we create for the child is most likely going to be irrevocable. If you want to have the ability to amend that in the future, there are ways that we can do that. That is something we talked about in my office. So really it depends on what your goals are as to whether or not a revocable or an irrevocable trust is appropriate for you.
Thank you.
I have a question. Can you hear me?
Yes.
Can you hear me?
If you have accounts at a bank or your brokerage firm that are payable on death, is that okay outside the will? It's totally outside and it's okay way to give your money away?
Yes, that's a very good question. So yes, the question is, if you have a payable on death designation on a bank account, does that take effect outside the will? And the answer is yes, it does take effect outside the will. In fact, we call that a non-probate transfer. Remember how I earlier said probate is changing title to assets. You die with a bank account in your own name. How do we get that bank account out of your name? Well, we probably have to have a personal representative appointed, open up a probate estate in the county where you were living, and that personal representative then goes down to the bank and says, hi, I'm here to take custody of this account. So that's the probate process. By making a payable on death designation, that makes that a non-probate transfer. It's going to transfer automatically upon your death to the beneficiary on that account, and it's going to do an end around probate. We're not going to have to go through the county to do that. It takes place automatically. So that's an advantage of it. But it has the other concerns that I have that I talked about earlier. What if you have different payable on death designations on different accounts? And what if we've forgotten who's the designee on each one? And so I've seen problems get created by that. But now I use that technique often in my practice, but there's some gotchas that I want to go over with you.
Right here in front? Yes.
Getting to where you had mentioned retitling assets into a trust name, is there a blanket form, let's say, to do that, where it would be like the title of your home, your bank accounts, all of that? Or do you have to go each one and basically say, like, for my wife and I, it'd be Mr. and Mrs. Joint Trust?
Yeah, unfortunately, it's the latter. So the question is, if you retitle your assets into the name of a trust, is there a blank form where you can do that with all of them at the snap of a button? Or do you have to do it asset by asset and change titles separately to each? And so unfortunately, it's the latter. You have to go through this with each asset. So if you have investment accounts at Morgan Stanley and Charles Schwab and Fidelity, you're gonna have to do a separate form for each of those. If you have real estate and more than one parcel of real estate, you're gonna have to record a new deed for each parcel of real estate you have. If you have several bank accounts, you're gonna have to do that for each bank account. That's another thing that I go over when you come into my office is, can we simplify probating your estate? And as I say it, there's no way to scale this to make it go faster. If you have 4 bank accounts that I have to change title to, that's going to take 4 times as long as if you have 1. So, and that's going to take your children 4 times longer to do it if they're administering your estate. So So that's one of the things we go over. Can we consolidate some of your assets? But with your real estate, probably not. But that means we prepare a different deed for each piece of real estate to convey it into the trust.
Right here,
If you have a,
Payable-
oh, I'm sorry.
right here in front.
Am I okay?
Yeah.
Is the payable on death designation the same as just having beneficiaries like on my bank account? Do you have to have two things?
Yes, it is. So the payable on death designation, Randy, you designate people as your payable on death beneficiaries. So that's the same thing.
And it's a form?
And it's a form that the bank has.
Oh,
You need to do that at the bank.
okay. Thank you.
Yeah.
Right here.
A revocable, living trust. If you just want to tweak a few things in it, you'd have to go back to the whole thing and do the whole thing, or can you just do some tweaks without big major revision?
That's a good question. So the question is, if you have a revocable trust and you want to make some small changes to it, what's the process to amend that trust? And so there's a couple answers to this. One is more and more I'm trying to name beneficiaries on a schedule that I attach to your trust document. So if you're changing your beneficiaries, and if I sense that, if somebody has a long list of their beneficiaries, often it's a single person or a married couple that don't have kids, that have lived here for a long time. And might have been lucky and bought real estate a long time ago, and Aspen is now worth a lot of money, and so suddenly they've got a whole bunch of unrelated people who are their beneficiaries. I'm gonna put that on a separate schedule. I'm not gonna put that in the body of the trust, because then I don't have to amend the body of the trust. Instead, I just amend the Schedule B that's attached to the trust. Or if we end up amending the trust, you can amend it with just a, simple one-page form. But what I also find is that if you've done that now 2 or 3 times, now you've got the Third Amendment and the Second Amendment and the First Amendment and the original document. If you want to understand the trust, you've got to read all of those to really follow the trust. At some point, it makes more sense to restate your trust and get a new document. And I'm constantly updating my forms. I don't use, I do all my own forms. And they change all the time. The guts of them go back 25, 30 years, but they're different all the time because the laws change and I learn things as I practice. So at some point with my clients, I'll say, hey, we probably ought to update to my current version. Now, I probate a lot of documents, or I administer a lot of documents that I've written, 10, 15 years ago. They still work. But like I say, I've been through the school of hard knocks, and so I learn things, every year, and I keep updating my form. So at some point, I would say that as well. So it depends.
Other questions? I just want to let you all know that maybe on your way out tonight, we're gonna hand out these red folders. And there is paperwork for you to look over and try to challenge yourself to get done. Next week, we will be hosting Dr. Shane Lieberman and Dr. Steve Ayers. And Shane is a palliative care physician. He works out of Valley View, but he works all over the valley. Really wonderful speaker. So I'm hoping that you'll come. The topic, of course, will be healthcare, finance and healthcare are the biggest issues that we are concerned about in end of life planning. So that's it.
Now I wanted to just say a few things. Can you hold the question just for a minute? Because I did want to say that in your folder, all of the documents that are there are not legal documents. Next week, we will hand out the medical documents. But these are advisory documents because we can't really get into legal financial documentation in an open forum like this. In our last workshop, so Teresa has said that next week it's the medical aspects of aging, especially, and living into your aging, especially. It's not all about dying, it's about living into your aging. And the last session will be a workshop to fill out the non-legal parts of your red folder. Because we're not going to be able to give you, we can give you some advice about how to get help, legal help, but we will not be able to give you legal help per se.
But there is help available.
But there is help available, yes, and Alpine Legal Services will have a representative here, and Alpine Legal Services also provides consulting through the Pitkin County Senior Services. And that information will also be in your red folder, and we'll go over it again next week. So, questions in the back there?
If your assets are, you know, my spouse and I are both listed as, you know, owning our house, cars and stuff like that, do we still need to retitle into a will or into a trust? So the question is, for a married couple, if they've titled everything jointly as joint tenants with right of survivorship, do they need a will? So, not, if you've done that, and it's hard to do that right, but if you've done that, no, at the death of the first spouse, everything transfers to the surviving spouse. And I say it's hard to do that right, because sometimes you forget, you miss assets. And, so, oh gosh, we have this one asset, now we're gonna have to probate an estate for that. And then secondly, there's two kinds of ownership, co-ownership between spouses, and that's tenants in common or joint tenants with right of survivorship. And if it's tenants in common, that means that upon your death, your estate ends up owning a 50% share of that real estate. While if it's joint tenants with right of survivorship, then that asset automatically transfers to the surviving spouse. So I like to describe this: joint tenancy has the assets going like this to the surviving spouse, while tenant in common has the assets going down to the heirs of the deceased person. So that will, then you miss, you're still gonna have to probate that estate if you have a tenant in common situation. And then the last thing I'm gonna say is, that works for the death of the first spouse, but now you've got a surviving spouse that has assets in the surviving spouse's name. Now, there's a probate that has to be opened at the surviving spouse's death. If in your situation, what I would suggest you look at is a joint trust, where you retitle all of your assets now in a single joint trust that has both you and your spouse as the beneficiaries. And now you retitle assets now into that trust. When the first of you pass away, that you don't have any more retitling to do because the assets are already titled in the name of the trust. And when the survivor of you passes away, again, you don't have to open up a probate estate. And so you do this one document. It handles your will need right now, and it handles probate for each of you. And it really does, your kids are gonna, if you have children, they're gonna love you for that, because it really does simplify things for them. Will y'all say your names, please?
So I'm Patty Fox. And this is Ken Ransford. And Teresa Hall.
Thank you.
You're welcome. Any other questions? Yes.
So you said if you miss something, so what if we go buy this new RV and we just kind of forget that it's not in our current trust? Does that have to go to probate?
Yeah, so that's a good question. What if you missed something? So in Colorado, you can probate an estate, a small estate with just an affidavit. It's called a small estate affidavit. I'm gonna prepare one for someone coming in tomorrow. And that's a 2-page form where an affidavit is just a legal document where you say, I have personal knowledge of such and such. That's what an affidavit is. And so this small estate affidavit, I fill it out for someone who has personal knowledge that the decedent, the person who died, as less than $88,000 worth of assets in their own name. And so I'll use a bank as an example. If you go down to the bank and you say, hi, I'm here to collect this bank account for my spouse who just passed away, they're going to say, what authority do you have? And you can say, well, I've been appointed as a personal representative. We've talked about how let's try and avoid that. Or I've got this small estate affidavit that says I have personal knowledge that they had less than $88,000 in their own name. And you sign that in front of a notary and you hand it to the bank and they'll accept it. You better hope that there weren't several bank accounts at that bank that collectively total more than 88,000, because then it's not going to work. But so we use that form frequently for a small estate. But and so what my discussion with your children would be about that RV is, well, it's not really worth 88,000, is it? But those are the issues here that and usually you can get by with that document, but not in the bank situation where the bank accounts total more than 88,000. That number, as you suspect, goes up with inflation each year.
Any last question?
Just, housekeeping announcement, if that's okay, sure.
I am Patty Kravitz with Pickens County Senior Services, so thank you for attending and thank you to our presenters and organizers. Please remember to register separately for the other sessions if you plan to attend. We are handing out red folders today. Please don't take extra copies for friends or family, where we'll leave extras at the Basalt Library that they can pick up, and we'll have them at Pickens County Senior Services. There's also a link, there's a sticker with a link in the folder, so you can give that link out to people. They can print their own copies, or anyone can email us at seniors@pitkincounty.com and we can give you that information. And for folks who are online, you can also reach out to the Senior Center if you need help getting a hold of the documents.
Hi, my name's Amy. I'm the director of the library. Thank you all so much for coming this afternoon, this early evening. We appreciate you and we appreciate our presenters. Thank you so much for coming again. As you can see, we do have empty chairs, so please bring your friends, encourage them to register. It's not specifically required, but we just don't want to turn people away at the door. So if you're registered, you're more guaranteed a seat in the room. So thank you again. If you're physically able, if you could help us stack the chairs in stacks of 6 along this wall, that would be super helpful. And thanks to all of the people online for attending. Everybody.